you have anything to say to the victims, Jesse? Why did you rape them, Jesse? Why did you rape the victims, Jesse? Why did you rape those girls? Why did you strangle them, Jesse?
That's Fox 25 capturing teen rapist Jesse Butler getting heckled as he enters into court to see if he's complying with the terms of his probation. Yeah, the guy who was charged with rape and strangulation and sexual battery after brutally assaulting 2 girls, he got to walk free. But we have a new development that may change his future. Could he wind up in prison? Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. By the way, real quick, it's the holiday season. Got to talk about this. If you're looking for a deal on maybe the perfect gift for yourself or somebody else, got to tell you about Chef IQ Sense Smart Meat Thermometer. Right here, this is the secret to stress-free, flawless cooking. So whether you're a seasoned chef or you're just starting out, this smart thermometer, it guarantees perfect results every time. There's no more guessing. There's no more overcooking. You just insert it, select your food, cooking method, your preferred doneness, you relax. Your app's going to alert you when it's time to flip, remove, rest. Perfect food every time. So from holiday turkey to prime rib, wings, brisket, salmon, it works for the oven, grill, a smoker, air fryer, more. You cannot mess this up. It is the gift that makes cooking stress-free and fun. Isn't that the point of it? And with my code Sidebar, you can save 30% off site-wide at chefiq.com. Do you remember we talked about Jesse Mack Butler? The teen rapist who got a slap on the wrist basically out in Oklahoma, avoided significant prison time? Maybe I should say for now, because we got an update that we got to talk about. He was charged with 11 counts. We're talking rape, attempted forced oral sodomy, sexual battery, strangulation, and there were more. And this came after 2 former girlfriends, they came forward about the abuse that they suffered. He was charged as an adult initially. By the way, this is a sampling of the accounts as they were laid out in affidavits about this baseball player. LS reported she yelled and told him no repeatedly and tried to push him off of her, but was unable to overpower him. LS reported Butler told her he was sorry for what he had to do, but he had to do it. Or how about this? LS told Butler she needed to get home, but Butler pulled her on top of him and told her, "You're not going until I'm finished." Then there's this. KS explained she learned what to do and not to do to avoid being hurt by Butler. According to KS, Butler would pin her down and she was physically unable to get him off of her. KS stated this would often lead her to hyperventilate, which Butler thought was funny. And we also played you body cam footage of when he was arrested, and his mom watched on.
Yeah, and I actually have a copy of the warrant, so I'll give that to you.
I'll just take the ID with me, and that way I'll give it to the detention staff.
Yeah, I can get it out. A little shaky.
Here, that's it. Thank you, ma'am.
24 Central. 24. 10:15. So my attorney told the police. Oh, my bad. That we would bring him in. So did you not get that message? I did, and I called back, and I never got a call back from him. When did you call him? Because he's called you several times too, he said. I've only had one voicemail from him, and I called him back after that. Sorry, I'm trying to get you a copy of this warrant. And I haven't received anything from him, so. Other than that one phone call. And that was several months ago. Probably like. You didn't tell him you were doing this today. Probably the attorney? Yeah. No. There would be no reason for me to tell him. But he left you several messages about Jesse. He left me one message, and I returned his call, and he didn't call me back. So that I took that generally. I don't want my client to talk to you. So when I return the message and then he doesn't make any effort to call me back, that's kind of what I have to go with. Okay. Oh, this is just a copy, but you can have that. Okay. So it has the charges listed and the bond and the case on there. Okay. All right. Thank you. Okay. You're welcome.
This is what got the community's blood boiling. He enters a no contest plea over the summer to the charges. But then there is this sudden reversal in court, which meant that the now 18-year-old wouldn't face nearly 80 years in prison, like everyone thought, which was a possibility. Instead, the judge gave him youthful offender status, switching his punishment from jail time to probation and mandatory therapy. Now, Butler's exact treatment plan, it's sealed in the court records, but USA Today reports that the DA's office released this statement where it says the youthful offender sentence imposed against Jesse Butler requires him to complete his rehabilitation plan successfully, including an aggressive schedule of therapy with a specialist in sex offender treatment, and should he fail, he faces reclassification as an adult and a sentence of 10 years in prison. Now, I mentioned that there is this recent hearing, right, where he comes into court and he's heckled by a protester. The reporting indicates that in that hearing, it was determined he is complying with the terms of the youthful offender deal. This is all shocking, by the way. It's shocking. The change in punishment, it sent shockwaves throughout the community. It had devastated the two girls who had gone to school officials to report what Butler had done to them. A mother of one of the victims told the outlet, Tulsa World, that the families were completely against youthful offender status from the very beginning, said that it was their understanding that the prosecutor trying this case wouldn't accept a deal like that. There have been calls for the judge who approved Butler's deal, Special Judge Susan Worthington, to be reprimanded or removed for signing off on this. One of the victim's parents, so KS's parents, sat down for an interview with ABC's Good Morning America. The mother saying, community service and counseling doesn't equate to what he did to her. Her father saying, I'm just hoping that his name will be out there, that somebody will know that he's capable of this, and just anything we can do to prevent other harm. And the family attorney, Rachel Bussett, told Nightline, I think there should have been a period of incarceration, and I think there should have been an admission of guilt of what he did. Now, why am I saying all of this? Because it brings me to a new development. There is apparently a legal push, and we'll see if it'll be successful, a legal push to change all of this, essentially, to maybe change the future of Jesse Butler. Ms. Bussett, this attorney, filed a very important piece of paperwork with the court on behalf of KS and her parents. So I want to do all this. I want to go through this document piece by piece, and I want to bring on Rena Paul, former federal prosecutor, going to explain all of this to us. Thank you so much for taking the time. First, before we even get into this, because you and I haven't really talked about this case, is it unusual to you that somebody who is facing these charges and pled no contest, have you ever seen a situation where this is their sentence? They're reclassified and they get probation status considering what he did to these two girls. I mean, have you ever seen anything like this in your experience?
From what I understand from the news reports, what happened here is that this is a youthful offender question, right? So in this case, the question is for the prosecutor in the first instance to determine whether or not they want to charge this now adult who was an underaged, under 18. I think he was 16 and 17 at the time of the alleged incidents. And the question for them on the first blush is, are they going to charge him as an adult? In Oklahoma, it seems, once that happens, then there's a second question of whether the judge is going to accept a motion from the defense about whether the judge will then treat it as a youthful offender treatment or not. So, I mean, yes, this is a statute that is used, and this is one of those cases where it begs the question, how serious does the crime have to be for it to have a discretionary look under the youthful offender statutes?
Sure. What would be a rational, reasonable explanation for why this should be the punishment? I mean, I'll talk about it in a little bit because they cite it, but minors who commit murder are sometimes, and a lot of times, charged as adults. This was a brutal attack on two girls.
Yeah, I mean, so if the question is, should this warrant non-youthful offender treatment, I think there's a lot to get into, to talk about. I mean, I think this also begs the question of what a sexual assault case entails for a person who is making a report, what it means for them to go to trial, how those decisions are taken into account by prosecutors to put somebody on the stand who is, in this case, two women on the stand or young girls on the stand, what that means. And plea decisions are made with those considerations in mind in sexual assault cases. And yeah, I think we could have a long discussion about what the difference is between how murder cases are viewed and how sexual assault cases are viewed and why those decisions get made.
So let's keep that in mind as we go through this, because this is essentially the argument from this motion, okay? This filing from the attorney who represents one of the victim's family members. Essentially, the argument is that KS's rights were violated and that under the law, there should be a new hearing scheduled, and hopefully, this is according to them, hopefully Butler's youthful offender plan would be modified. It says, quote, "The victim received no meaningful or timely notice or consultation regarding the state's agreement on Butler's certification as a youthful offender. The defendant's conduct was not a single youthful indiscretion, but a pattern of escalating violence over approximately 11 separate incidents during a 7 to 8 month period. The state's entry into a plea agreement without meaningful victim consultation violated Marcy's law, depriving KS of her rights to reasonable notice, to confer with prosecutors, to be heard at critical stages, and to be treated with fairness, dignity, and respect. Butler took no responsibility for his conduct, did not acknowledge or admit to what he did, and ultimately pled no contest to all charges, including the violation of the protective order, and was not sentenced to incarceration. The victim was not meaningfully notified of ongoing plea negotiations and was unaware of the no contest plea and its terms of non-custodial disposition until immediately before going into court, and was subsequently accepted by the court on August 25th, 2025. The victim now moves this court to enforce Marcy's law and set aside the plea agreement and reset this matter as an adult prosecution, or alternatively, if the court determines that it should remain a youthful offender, to require the defendant to allocate." Okay, lot there, Rena. First, let's start here. What exactly is Marcy's law, and what are the legal and maybe moral responsibilities of a prosecutor in communicating with a victim or a victim's family during the criminal process?
So Marcy's law was a national movement, I guess, that aims to ensure that victims of crime have constitutional rights in the system. And Oklahoma passed their version of this in 2018, and it gives rights to crime victims. Some of the rights we're talking about: timely notice of hearings, the right to be present at proceedings, some proceedings, key stages, the right to confer with prosecutors. And, there's a list, and depending on the state and the way that the law is interpreted in that state. So it does just most basically, it gives rights for crime victims to be heard and be present during the process.
And let me be clear, this is probably going to be a factual dispute because I'll get into what the DA's office says. But assuming, for argument's sake, that they weren't properly notified, even though the DA's office will probably say, assuming they weren't notified, they didn't know what was going on, is that an egregious violation where there could be a change in what happens to Jesse Butler? And we'll get into a little bit more of the specifics in this motion, but generally speaking, have you ever seen a situation where there is allegedly an egregious violation of their rights, they're not informed, and there's actually a change in the disposition of what happens to a criminal defendant?
Yeah, well, I want to back up just to talk about something fundamental that is worth talking about when you talk about rights, right? So when someone comes to me and says that they are considering what they want to do after being assaulted, and they're talking about the criminal system, one of the first things to understand is that in the criminal system, when you make a report, you are a witness, right? You are not any longer in charge of what happens to that case. You are a witness. And that means that that's because the prosecutor has the responsibility not to victims or to defendants, but to both. And that is the way our system works. And as somebody who does represent, has been a prosecutor and does represent people who have been victims of such crimes, I mean, that's a really serious question for someone to consider when they walk into the system.
Okay.
So talking about that, when you think about that from that perspective, the prosecutor ultimately makes a decision. It really isn't for the victim to decide anymore. The rights of the victim are about notice and about what they are, the window that they're given into the case, but it's not that they are given all windows into the case or decision-making power. So that's an important piece to understand too.
They can't decide whether or not a deal should be given or accepted or something. Okay. But if their rights were violated, okay, for argument's sake, can it be? I'll tell you what. Let's hold that, whether or not, because I'll go through it, about whether or not their rights were violated in such a way that there could be a significant change, a new hearing, something happens with Jesse Butler. Let me go through this. So first, they talk about enforcement of Article 2, Section 34, Oklahoma Constitution, Marsy's Law. Pursuant to the Oklahoma Constitution, the rights of a victim shall be protected by law in a manner no less rigorous than the rights afforded to the accused. It says this section delineates and mandates that a victim has absolute rights to be informed prior to any negotiations, plea agreements, and hearings in advance of any plea negotiations and hearings. There's a provision that also requires the state's attorney to confer with the victim prior to a final disposition occurs to any plea agreements or proposed pleas. If these rights are violated, the constitutional protections and safeguards under Marsy's Law specifically allow or expressly authorize the victims to have standing and to assert and enforce these rights. The victim's constitutional rights were violated in every provision outlined and delineated in the preceding paragraph because there was not any degree of notice as to the modified certification regarding the youthful offender status, nor a nolo contender plea and dismissal of multiple charges or counts. Although the defendant committed numerous heinous crimes causing great bodily harm that was nearly fatal, the victim was not given meaningful notice of the plea negotiations or an ample opportunity to talk with the prosecutor about the deal before it was locked in or made behind closed doors, and not fully heard nor interviewed as required before the judge approved the sentence, which are all constitutional or Marsy Law violations. Rena, is that accurate?
I'll tell you what I stick on because I'm a lawyer and lawyers stick on words, right? So I listen to the words meaningful, ample, and fully in there. A meaningful opportunity, ample time, fully. I don't remember what that modified, but here's the question. The question is, that's going to be what it comes down to. I think the answer is there. I'll give you a lawyer's answer too. It could change the course of it, right? So then the question, the considerations of that are going to be about what does it mean that it was meaningful? How meaningful was the opportunity for them to weigh in? And what would the prosecutor say about that? Were they informed? What does that mean? It may not feel, and I don't know specifically, of course, in this case, just generally speaking, does it feel, the questions you ask are, does it, even if it doesn't feel meaningful for the victim, was it meaningful under the law? Did they have the opportunity under the law? And that is really a question of the way that prosecutors interact with crime victims, which is kind of the genesis of this whole law to begin with. But different prosecutors do things differently, and the way that they notify, when they do, how trauma informed it is, how trained they are in those kind of practices. Those are the things that you think about when you want to ask the question of what was done here and whether it's going to make an impact to the bottom line of this case. But certainly from this motion, you can tell, at least from the perspective of the victim's attorney, that it made an impact to her.
Let's keep going. It says the only notice or consideration that was given to the victim consisted of approximately 10 minutes prior to the plea bargain agreement, and she was never given an opportunity to be interviewed or supplement the pre-sentence investigation report with her victim's impact statement, nor was she afforded an opportunity to be privy to any other information outside of forensics prior to the closed or private agreement, which goes directly against the policy that is aimed to promote and protect the victim's rights. The victim was also misled on the court's role in prohibiting this from moving forward as an adult charge. The DA has the sole authority to decide whether to file the charge as an adult. Furthermore, the plea agreement was directly contrary to the victim's consent. The victim vehemently disagreed and objected to the plea agreement and the correlating leniency or mitigation as part and parcel of the youthful offender status, which allowed the defendant to avoid time in custody. So, Rena, again, you see this new this additional set of allegations about how much time they were given, being part of the pre-sentencing report. Your take?
Let's talk about just the process of what generally happens to talk about how this motion is saying that they deviated from the process. So typically what happens is once the plea is taken, there's a pre-sentence report that is made by the probation department, and the victims have a right to weigh in at that time and weigh in the form of oral testimony or written statement or something, so that the probation department or whoever is writing up that report can have their take on what they think and then present that to the judge who can consider it. So when they are referencing in this motion, supplementing the pre-sentence report with their statement, it's unclear to me from reading that whether or not they did do that already or not, or it was that they wished to supplement it further than they had on the initial go around with it, if that makes sense. So that's one piece of it. And them, as far as them being privy to information about the way that these decisions are made, certainly, as I said before, I mean, it is not, there's a difference between notice and taking into account what the victim would want and the bringing them inside of the decision-making as the prosecutor, which is not typically what happens. Certainly most prosecutors will ask for the take of the victim, will want to know what they want and understand where they're coming from. But that doesn't mean that they're going to do what they want.
Mm-hmm. Well, this is what they're hoping for. It says, quote, as a result of these direct violations, the movement is requesting that the defendant's plea or final disposition through sentencing be vacated. Alternatively, the victim seeks formal recognition that her rights were violated during the plea and sentencing process, a new, fully compliant hearing at which she may be genuinely heard, and such modification of conditions and terms as the court, in its discretion and within statutory bounds, deems necessary to restore fairness, protect public safety, and to give effect and compliance to the victim's constitutional and statutory rights as required. So, Rena, if I'm understanding, and this is, by the way, part one, we'll get into part two. They're saying, okay, can you resentence, like throw the sentence out? Let's have a hearing where I can properly be heard. Or can you modify his probation conditions in a way? Are any of those realistic possibilities, whether you've seen it in this state or other states?
I mean, I think anything's possible, right? This is a constitutional right. So the question is, if who's going to make this decision, which is the district court, and how egregious was this, and what are the conditions? So the first question that's going to be answered is, were the rights violated? And that goes back to the nuance of what the rights are, which are pretty broadly stated in the Marsy's law, and how they were done here. Or complied with here. And then the second is, okay, if it's true that they were violated in any way, what's the remedy? And, it sounds like that would be in the discretion of the court that's deciding it, and whether they would send it back to redo, whether it would be vacated completely. I think that would be up to the court they're filing this motion to. And certainly anything's possible when it comes to violating a right like that.
Let's move to a similar argument. That she's entitled to relief or enforcement through the Oklahoma Victims' Rights Act. It says, quote, these statutory requirements also mandate compliance of victims' rights and duties to be informed and provided with adequate notice and an opportunity to be heard. Similarly, the Oklahoma statutory provisions guarantee the victim's right to notice, consultation, and participation, and imposes corresponding duties on prosecutors. And she makes the argument that there is nothing under this statute that prevents a court from, quote, reconsidering its acceptance of a plea agreement before final judgment or sentencing, or vacating or modifying an unexecuted sentence in order to remedy ongoing violations and to afford the victim a meaningful opportunity to exercise her rights. So two questions I have here, Rena. One, why also include this section? And B, does this also provide a realistic avenue for there to be a change in Jesse Butler's status?
Yeah, well, I don't practice in Oklahoma, so I'm learning about Oklahoma from reports, but I'll tell you, it seems that there's another statute that predated the Marsy's law in Oklahoma specifically. So, there's federal statutes and state statutes, and the state statute seems like it existed prior to also the Marsy's law. It seems like it overlaps a lot of the same considerations of the Marsy's law. So it has a lot of the same things to say about what victims can do. And when they to enforce your rights, you file a motion like this, you ask the court to do something about it. So it would be the same deal as the Marsy's law violations. And they would use it because they would use any law that would, right. If a good lawyer would use any law that's possibly relevant to make this motion, right? So that's why I would imagine that they're both in here.
I want to go to this argument. I thought it was interesting that reverse certification isn't allowed, right, to go from an adult to a minor when you're dealing with a rape one charge or attempted rape one. So they say Jesse Butler was 16 and 17 when he committed the acts against the victims LS and KS. Under the law, he may be charged as an adult or a youthful offender. This section mirrors the language, and this is in a different statute, which does not allow reverse certification for a murder one charge by a 15, 17-year-old. So they're comparing it to that. This is colloquially referred to among prosecutors and defense attorneys as the straight to jail provision of the law. Had the DA maintained the prosecution under this statute as she originally filed it and as the victims wanted, Butler would more likely than not have gone to prison or at least had a record as a convicted sex offender upon the entry of a plea of conviction. Instead, the victims were led to believe that this was not a possibility and that the court held all the power. The district attorney retains the sole decision-making authority on how to charge and either misunderstood or misled the victim on the court's authority to reverse certify Butler as a youthful offender. The DA charged him as an adult and retained that discretion to keep the charge. KS and family were led to believe that was outside the DA's control and within the control of the court when that is an incorrect application of the law. This violates the victim's rights. So this is a big part. They're basically saying this is not allowed, can't do this reverse certification, but also the DA either doesn't know the law or they misled us on what should happen here. They should have told us what the court can do or what they can do. This is a big allegation here.
Yeah, the one thing that I did not see in the news reporting clearly was what the prosecutor's decision was after the court decided to proceed as a youthful offender, whether that was a plea agreement that they consented to or whether or not it was over their objection. And that was not clear. Maybe that's what's being referenced in this motion. It was not clear to me from the news reporting. But yeah, this would be about the necessity for prosecutors to communicate effectively and clearly to crime victims. And listen, it's very challenging to be in that position because you have heightened emotions, a very sensitive issue, and you are not, as I said before, you are not the representative for the victim. You are the representative for the state. And that puts you in a different position. And you are also dealing with a person who is a witness, right? Now,
right.
Just to think, taking it out of sentencing, just more broadly as just a talking point that's interesting is that when you think about that as a prosecutor, when you're speaking to a victim, you don't want to say something that may impact the way that they would testify should they ever end up on the stand. You want them to preserve their own experience, and you don't want to put anything into their mind that may change, or impact the way that they relate to it, right? So when you're speaking, you have this kind of dual function as a prosecutor that makes those communications tough. And, I hear it from this motion that at least through the attorney for them, that they were not feeling that they understood. And yeah, I mean, that's difficult.
Yeah, and they go into, again, under this provision, how they believe their rights were violated during the sentencing process and the plea process. And it goes back to this question of what's the relief. It says, quote, a corrective hearing at which the victim, through counsel, is fully heard regarding the plea. The youthful offender disposition, public safety, and the impact of the offenses is necessary to restore integrity to the process and to give effect to Marcy's law requirements in this case. We believe the corrective action is required under both constitutional and statutory provisions, which would require a hearing based on a complete record that includes the victim's input, interview, and consideration. At that time, the court may consider modification of existing conditions or the imposition of additional supervision requirements, no contact orders, unsealing the victim's protection order, ordering a permanent victim's protective order, and other safety-related terms that are consistent with the youthful offender statutory framework and the interest of justice. Set this matter for a new sentencing hearing to allow the victim to be fully heard, informed, briefed, and conferred with through the attorney for the state. Rena, this can't be ignored. What do you think the court is going to do here? Because I will tell you this much. Let's just end on this point. The district attorney's office told ABC News that they did, in fact, consult the victims' families throughout the process, warn them that this could happen. In fact, in a statement to ABC News, Payne County District Attorney Laura Alston Thomas defended the actions of the office, saying the three young people involved were all 16 years old at the time of the alleged crimes. Each of the allegations was reported to have occurred during consecutive dating relationships, and none of the allegations was reported until after the relationships had both ended. These circumstances do not justify criminal behavior or minimize victim trauma, but they do impact the evidence available for a prosecution, and they also impact potential defenses. We discussed these factors at length on multiple occasions with each family, including advising them from the beginning that this matter would likely end up as a youthful offender prosecution and could even end up in juvenile court. So you're seeing two different narratives here. Rena, let's talk about what we can expect. Is a hearing going to be set up where you have their arguments and you have the DA's arguments about who was consulted, were their rights violated, is that going to happen? And that could necessarily determine what happens next to Jesse Butler?
I mean, I don't have a crystal ball, but I don't think if I had to give my best guess, no, I don't think that such an extensive hearing is going to happen. The question about remedy is one of what was the violation. The remedy isn't about undoing the prosecution or the decision making. The remedy is about the violation of the victim's rights. So what would remedy those rights? And just kind of colloquially, I don't think that necessarily taking apart the entire decision-making process publicly is going to be something that would be a court was going to decide as the remedy for that violation. But whether there would be some sort of scrutiny or some sort of look at it is a different question. I mean, I think it depends on how egregious it is. But listening to what you said about the DA, which I had not read, that's a different question. And that's really at the heart of where we started about the difference between a homicide prosecution and a sexual misconduct prosecution or assault. And it gets down to the references there about, dating violence, consensual relationships that lead to behavior that is assaultive. And what are we as a society, as a media, as the justice system able to do with cases like that? I mean, we all just went through and lived through watching the Diddy case happen on TV and the coercive aspects of that being talked about in the media in every which way. So that's really the question that I think this case begs, is about what do we do with sexual assault cases, especially teen sexual assault cases, and how do we look at those, and why in at least under the state statutes, it seems like in Oklahoma, murder is different than that, because in the state statute in Oklahoma, it seems like murder is just plainly as an adult, but a violent sexual assault is a discretionary call. So beyond this case, I think that's a question that this case begs.
That's a very fair breakdown, a very fair assessment of what we can expect. For anybody who's following this and anybody who just maybe watched till the end of the video to get the main conclusion, for those who are saying, okay, Rena, Jesse, tell us, is Jesse Mack Butler going to prison? Your answer would be?
Even if what you're suggesting, the hearing was evaluated, as I said, I don't think that the remedy for this violation, if it was a violation, is going to be a change in what the outcome is.
Rena Paul, thank you so much. Appreciate it.
Thank you.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.